Well, before I went to work full-time for the gay rights movement, I worked as a prosecutor in the Brooklyn District Attorney's Office. So I did a number of criminal cases, both at the trial and at the appellate level. When they found out, because I came out, that I was gay, and they found out because I came out to them because I wanted to volunteer in my free time to work at Lambda Legal, the gay rights organization, and I wanted to donate my time as a pro bono attorney on weekends and so on. No district attorney had ever tried to do that before, so they had to go through this whole process of deciding, was that something you could be allowed to do? And it actually went all the way up to the district attorney, and of course in the process I had to say why I wanted to do it, and I talked about being gay. So as a result, I came out as gay at the workforce. Not that it had been a secret, but now it was an issue. And they were absolutely fine with my doing the pro bono work in my free time with certain rules that were legitimate. And the unintended benefit of that was not only did I get to do the pro bono work for Lambda, which got me involved in writing back before we had computers, so I was writing on little yellow pads in my brownstone on the weekend, briefs that included participation in the Bowers v. Hardwick case, which of course was the terrible Supreme Court case we lost regarding private consensual sex back in 1986, and other important gay rights cases then as a junior attorney. But the Brooklyn DA said, well, if this guy wants to be going out and doing these fancy constitutional cases on his free time, why don't we actually have him doing it for us as well? So as a result, I wound up not only getting to do important and good constitutional work through Lambda Legal, but through the Brooklyn DA's attorney, I was assigned some of the interesting constitutional litigation as well. So I wound up working on the case that actually ended peremptory challenge, race-based peremptory challenges in jury selection in front of the US Supreme Court. And one of the important cases was a case in New York involving a man who had raped his wife and then invoked what was called the marital rape exemption, which was a part of the law at one time of every state saying that a man can't be charged with raping his wife because he's entitled to take what belongs to him. And the Brooklyn DA came in against him, saying he ought to be prosecuted, and there ought to be an ability to prosecute him. And that was an important constitutional litigation that wound up striking down that marital rape exemption, which, believe it or not, still existed in the definition of the law of marriage, even in New York in 1984. So one benefit of coming out was not only did I get to do the work for Lambda Legal, but I also wound up doing constitutional litigation through my main job, my day job, which was the Brooklyn DA's office. After I left the prosecutor's office, I did a stint with the Office of Independent Counsel investigating the Iran-Contra affair, and so I worked on a variety of questions there, and then left there to come back and join Lambda Legal full-time, where I worked for 12 years full-time, having done 5 years of pro bono work. And while at Lambda Legal, I worked on really the range of AIDS and lesbian and gay rights cases. Some of the most interesting ones were challenges to the military discrimination against gay people, seeking parental and custody rights and visitation rights for gay parents, lesbian and gay parents, striking down a deputy sheriff in Florida was fired for being gay. And I went down and actually did Lambda Legal's first jury trial in front of a Florida jury. Very colorful situation. We were actually picketed by the KKK outside the courtroom and wound up overturning his dismissal and winning that case there. But the cases that I'm most known for, and that were, I think, really my most important, were three. One was a case suing the city of New York for failure to provide health benefits to unmarried city workers, and it was called the Gay Teachers case. And we wound up winning that case and requiring New York City to provide health coverage, not simply to married partners, but also to unmarried, both gay and non-gay. So that was a very important case that began paving the way toward, of course, the marriage fight. The other two big cases were the Boy Scout case, where I represented a wonderful man named James Dale, who had been in the Boy Scouts for more than half his life and then was expelled for being gay. We won a unanimous ruling from the New Jersey Supreme Court saying that that violated his rights under the New Jersey civil rights law. The Boy Scouts appealed that to the Supreme Court, and so I became the first Lambda legal attorney to argue before the U.S. Supreme Court on behalf of James Dale against the Boy Scouts. We actually lost in court. The court ruled 5-4 against James, but I felt always then that we had lost the case but won the cause, because we had really educated the country on the existence of gay young people, including admirable people that really anybody looking at James talking on TV would feel like this is a son they'd be proud of. And people had to rethink their understanding of who gay people are, not as some others outside coming in, but rather young people within every organization, including as bedrock an American institution as the Boy Scouts. And then and that was, I think, probably my highest publicity case for most of my time there. And then the other one that was really most significant was the Hawaii marriage case, in which I was co-counsel along with a non-gay man named Dan Foley, based in Hawaii, on behalf of 3 couples in Hawaii who had been denied marriage licenses and sued. And that case led to a trial in 1996 where we, for the first time ever, stood on behalf of couples in front of a judge, having won them the day in court to be able to argue as to what reason did the government have for excluding them from marriage. And we actually won that ruling, the first trial court to rule in favor of same-sex couples, and the judge found that there was no good reason for denying these committed couples the freedom to marry. That case was then appealed to the Hawaii State Supreme Court, where before the court could rule, it was taken away from the court by a constitutional amendment, which set the pattern for some of the events that have followed. So though we didn't win the freedom to marry in Hawaii, we launched the national and even international conversation that has continued about marriage equality ever since. And that's the case that I'm most proud of.